Week 2 of the Lori Vallow trial begins with yet another juror issue. A juror is late. Now, this isn't a major deal, but you have to remember we've already lost 2 jurors and there's only 2 alternates left, so personally I get a little worried when I hear any issue with the jury. Thankfully, they showed up. Maybe they were just late due to the fact they started 30 minutes early today. Now, the state has multiple motions. One is on a subpoena served to Bobby Vallow, a motion about questioning of police, a motion to preclude defendant's witnesses again, motion in limine for testimony about a video seen by Janice Cox and Summer Shiflett. The state also says they want Brandon Boudreaux and Bobby Vallow to have their subpoenas sealed as a matter of victims' rights, and that's something they want to discuss immediately, and the judge just agrees, and the rest of the motions will be discussed later. So that should be, I believe, talked about today, and we'll cover it later in this video if it is. Due to a juror being late, they started scheduling for the next trial. Yes, the next one. Remember, there's a second Lori Vallow trial coming up. I'm not going into specifics because, honestly, it's so far off that anything could change. The judge is leaving the area at one point. It's a whole thing. But they do expect they'll need 300 potential jurors to find those they need, factoring in the publicity issues from this trial. Remember, if you're in this area and you didn't know about Lori Vallow before, you might see this coverage. You might be watching this video, therefore you can't be a juror in the next case. The first witness is Dr. Derek Bumgardner. He explains his qualifications and how autopsies are done. He did the autopsy on Charles Vallow. They bring up the Charles Vallow autopsy photos, which of course are not going to be shown to the public. Well, the public online. The public in the courtroom, they see it. The first photo is a photo of Charles's face used for identification. Charles Vallow was under 6 feet tall and just over 200 pounds. No injuries to Charles's face or head, no contusions you would see if he fell backwards after being shot. They show the gunshot wound, saying it happened around the time of death. Right hand, no abrasions. Left hand, there was blood transfer on his hand, and no abrasions. I'm saying no abrasions here, but there is an update in a bit. Left hand, there was blood transfer on his hand, but no abrasions. Again, I just reread that on accident. Charles Vallow was wearing a watch. They have to explain why. The body isn't touched as much as possible until an autopsy, so things like a watch remains on. And the watch wasn't damaged. There was damage to Charles Vallow's knees, received around the time of death. Next are close-ups of the gunshot entrance wound. There was stippling on the injury. And the medical examiner, the autopsy guy, whatever his exact title is, explains that he did not use the word stippling in his report, but he did describe it. The muzzle was 2 to 4 feet away according to textbook, but exact ranges would have to be tested for that particular firearm. If it was any closer than that, there would be soot, and he didn't see any soot. They show the exit wound. He explains how exit wounds are different shape than the entrance and generally larger. The witness explains how the bullet passed through Charles's heart. The wound was not immediately fatal, so he could live for up to a few minutes. He could speak and move during that time. He could touch his chest with his left hand and have fallen to his knees. The wounds on his knees do match that scenario. They show and explain the trajectory rod. It was front to back, right to left, slightly downward for this particular injury. Now, this could be due to the angle of the gun, or the difference in size of the shooter. So if the shooter is taller and you're shooting downward just because you're taller, that could do it. They talk of the other gunshot wound on the abdomen. This one had no stippling or soot, so it was most likely from 4 or 5 feet away. This exit is found in the upper left shoulder. This exit wound is a shored exit wound, which happens when a firm surface is against the skin. You would expect this if someone was on the floor. He has never seen a shored wound from someone wearing a t-shirt. He has seen less than 50 shored wounds, but this is a textbook-worthy example. This shot went through Charles's lung and his ribs before exiting the shoulder. Trajectory was front to back, left to right, and upward. And they show more of the photos to explain it. The gunshot exiting his back was not shored, the one for his shoulder was shored. The shored wound would be consistent with someone shooting from Charles's feet as he was laying on the ground. And they asked if there was a defect on the floor under his shoulder that would match the shored wound, and the answer is yes. No drugs or alcohol were on Charles Vallow's system, and he died of gunshot wounds. And this is where Lori gets to cross. And I don't know about you, but if there's anything other than green chili chicken enchiladas, which I still have some leftovers of that I don't know if they're good or not. I'm probably going to eat them anyway. But I wonder about bamboo. I felt at this point she's going to have to mention bamboo. That's another thing I'm remembering from this case is the bamboo. Lori begins, though, by asking what drugs they test for, and he lists some of the things that were tested. Lori says medications like blood pressure and things like testosterone or human growth hormone, and no, those weren't tested. The wounds of Charles's knees were near time of death and could have been from a scuffle before the shooting, same as the abrasions on his hand. And at this point I have a note. So I went back because I thought they said there were no abrasions on his hand, and I went back checking, and as far as I heard it, maybe I'm mishearing it, I didn't hear them say there were abrasions, but I only listened through it twice. I did check reporting of people inside, and they said there was a small abrasion on his left hand. Maybe that was visibly shown, and I couldn't see it, but there was an abrasion according to people in the courtroom. I'm going to take their word for it. Lori asked if Charles was still falling during the second shot, if that would cause a shored wound, and the answer is no. And anyone watching this trial should know that after all the explanations, because if he's actively falling, there isn't a hard surface behind him. Lori asks what if he bounced? And again, the answer is no. Lori asked if it could be caused by tight clothing. The witness explains it would have to be something tight like a belt or a bra. The witness doesn't know about bamboo clothing or how tough it is. Of course, Lori had to talk about bamboo. Lori is done, but it's redirect time. If the shirt caused a shored wound somehow, then it would have caused a shored wound to both exits, which wasn't here, which is a good point. If he's wearing this shirt, if you're wearing a shirt that is tight-fitting, so tight it's going to do a shored wound. It'd have to be like as tight as a belt. But if it's that tight, you're going to see that in two locations because you're wearing the shirt and both exits are in shirt area. And that's not what happened. There was nothing in the Charles Vallow autopsy to indicate he died of anything but a gunshot wound. I don't know why Lori was talking about testosterone and human growth hormone, maybe claiming he roid raged out. I'm still of the opinion that she's going to eventually blame it all on Tylee. But maybe she's also going to add in that he was roid raging or something. She's got to be working through what her final claims are right now, because even though she began with the evidence will show in her opening statement, the evidence isn't showing anything, right? And a lot of this evidence doesn't exist because the only person who can say these things is Lori, who was there. So if she decides not to testify, it's just she threw that out there as a truth and there's no verification of it. There was a jury question, and at this point, they put on the headsets and all that. There was no significant amount of blood in the lungs, but there was blood in the left chest cavity. Heart may have not been beating at that point, but there was no blood in the throat or mouth. State follow-up: when someone is shot in the heart, blood is expected to be in the left cavity. Next up is Mark Sari. He works for the Office of the Inspector General and investigates fraud and abuse for the Social Security Department. He explains survivor benefits. When a child becomes an adult, those benefits drop. If a child is adopted, those benefits then go to another individual. We are knocking on the door again, right? Because Lori told Chad about the benefits she would get due to JJ. Killing him could have been a way to keep the benefits after Charles's death flowing, as Kay would have possibly taken JJ, and of course, they can't have the body be found because then they'd stop. And if you have JJ around, he's going to cost money. And Lori doesn't want to spend money. Not on her kids, just on herself. The mother can get benefits if they were married at the time of the parent's death. So Lori can get her own benefits. If they are not married, the mother doesn't get those benefits. The benefits disappear if the mother gets married again. So again, any benefits Lori was getting would disappear by marrying Chad, but not JJ's benefits. This man looked into survivor benefits for Lori and JJ Ryan. He also found out about benefits that were being provided to Tylee Ryan. So, the benefits that Tylee is getting were $1,859 per month. And the payee for Tylee was Lori Vallow. So Lori is getting Tylee's money. Money, money, money. You're going to hear more about money. You're going to hear more of Lori excusing how she spent that money, too. Those benefits are typically in an account both the parent and child can access. You have to apply for survivor benefits. Lori Vallow did one of the meetings to apply and had to give information. Lori was asked when they got married and she gave it. Lori was asked, was she living with Charles Vallow when he died? And Lori told Social Security they were living together at the time of his death. Lori was granted a Social Security payment of $1,951 per month, plus a back pay of $4,157. This would be almost $4,000 a month because Lori would get hers and JJ's. But don't forget, Lori was also getting Tylee's benefits, so we're talking of her raking in about $6,000 a month. The witness learned Lori remarried to Chad Daybell on November 5th, 2019, which would have gotten rid of 2,000 of those benefits. The majority she would still get because of the kids. Now, Lori is up to cross at this point. A surviving spouse can get benefits without any children. Lori asks if there are two spouses to a deceased husband who both have married to him for over 10 years, would both get the survivor benefits, and the witness doesn't understand the question and then said he doesn't know of that policy. Lori asked if it is explained to me, I could receive that, and the objection sustained. Witness said you'd have to ask an expert. This witness investigates fraud. Lori asks if the witness doesn't know what the employees tell the people who come in for the appointments. Lori asks if mother and care benefits are for a child. Yes. So the benefits Lori was getting from the death of Charles were supposed to go to the child. Lori asks how it is decided if a spousal benefit or a mother and care benefit, and the witness says the person applies and then gets a letter in the mail for an appointment where they go over it all. There wouldn't be a confusion on what you are applying for. So Lori is trying to put that she wasn't trying for mother and care, she wanted the survivor benefits, and they're telling her that's not how this works. Lori says if I were told, again, objection sustained. Lori rewords it with a hypothetical with recipient was told. There was an objection, but the judge is allowing it because she's pro se and the judge is going to give her more leeway. It is up to the applicant to let them know if it's the wrong benefit. So if it was wrong, it's Lori's fault. So if the employee, what is this? So the employee would bring it up to the applicant if it was wrong to fix it. And the witness says it's based off the applicant and them being truthful. Well, if the Lori did it wrong, if the employee did it wrong, would it be up to the applicant to fix it? And the witness says it's based off the applicant being truthful. So I want to interject here because I'm not sure how I worded this well. They explain it really well that you fill out the forms. It's kind of like people like, well, I don't know how I got to the screen on my computer. You choose the buttons you press, right? Like you make all the decisions. So the only person who can screw it up is Lori. Lori doesn't want to admit she did this, but that's what it's about. Witness says it's based off the applicant and being truthful. Lori asked if he has Lori's application for the benefits, and he said ask the prosecutor for that. I believe he physically has it in front of him right now, by the way. Survivor for JJ and mother in care as well. And Lori asked she didn't have a survivor benefit application. And he repeats again that he covered the JJ and mother in care. She did not have a survivor benefit for herself. It was mother in care. Lori says so it could have been a mistake on the employee. He says they rely on the information you provide. Lori was present through the application and when they went through it line by line. The witness reviewed any and all documents for Lori and JJ. Lori asks if they are redundant benefits, and Lori doesn't understand, it seems, that JJ had a benefit and she had a benefit, and that both those benefits had to be used on him. Basically, what I'm getting at here, and let me know in the chat, 'cause I'm going to put this up for a preview. Let me know in the chat. Let me know in the comments if you're late. If I'm understanding this, if you watched it and you agree. Lori knows she blew all the money, right? And she believes that by saying it was a survivor benefit, her blowing the money is okay. But if it was for JJ, it wouldn't be. So Lori is trying to claim that she was falsely put under a mother benefit because she wanted the money for herself. If that's making sense. Lori knows she blew the money, and this whole thing is her trying to explain it, to alleviate herself of that to the jury, because if the state goes into it, there's probably some purchases she doesn't want to be brought up. Lori asks if the benefits are supposed to be used for the benefits of the child, and the answer is yes. They do an audit to make sure. Lori says you have to spend it every month and you can't save it for college. So again, Lori is basically like, well, I have to spend all the money. And the witness explains to her, no, you don't have to. Lori says if an employee told a recipient that they can't be saved, is that wrong? And he explains that saving it for the benefit of the child is allowed. So right there, Lori is definitely worried about how the jury is going to think about her blowing all this money that was meant for JJ. Lori pushes the same question, objection, and the judge said that she's trying to testify. And again, I put in my notes here. She's trying to justify why she blew the money. That has to be it. She tries again, sustained. Lori confers with counsel. Witness was not present at Lori's interview and doesn't know what was said. He investigated the fraud starting in January 2020. This is while the search for JJ and Tylee were in full force in the news, but before Lori's arrest. We are knocking on that door again. If she pushes into why it was being investigated, we could lead into that. Also, she has a new marriage, but people found out about the new marriage, it seems mostly, during the children being missing. So, I paused to write my little notes there. I was very attentive. Lori asks who his boss is. Objection, relevant, sustained. Lori's asked who assigned him the case, a now retired employee. He gives a name, but it doesn't matter. Lori's done. Redirect. August 12th in 2019, Lori had her meeting to apply for benefits. A letter was sent to Lori in Arizona covering all her answers. They lived together, her kids, what she was applying for. Social Security doesn't start giving benefits without the applicant applying for it. When a spouse dies, both the spouse and child can get benefits. Lori knew how much she was getting, one for JJ and one for mother and care. No surviving spousal benefits, which again means that none of the money was actually for Lori. Witness says on Lori's marriage to Chad, the benefits would cease, but benefits for JJ would continue. So there we have a little bit of motive. So Lori's half of the money disappears on marriage, but JJ's doesn't. There's a jury question and a sidebar. We'll get to more information about this later. The sidebar had some issues, and it doesn't come up till later. Lori Vallow's payments were stopped after the investigation. Knocking on that door again. Sure, the marriage dropped hers, but JJ's death stopped his. That is... Lori Vallow did not tell Social Security of her new marriage. Lori has a follow-up. She asks if she didn't notify Social Security, and he says to his knowledge she didn't. Lori says, so you don't know while in Hawaii I notified them. Objection, sustained, testifying. Lori asks if he would have all information of every office, and the witness says it wasn't in the record. Lori says the witness looked at at least the records the witness looked at. He explains it was in a database for all offices and there's nothing there. 0 notifications. An employee would have to make a change and it would be seen. No changes in November and he would know it. He did not miss it. Redirect. Social Security uses computer systems so anything updated anywhere in the country gets updated and nothing was missed. Social Security wasn't told she remarried. We're up to the next witness, and this is Robin Smith Scott, custodian of records for Banner Life Insurance. And immediately my mind goes to Robin on the phone with Lori when Lori found out she wasn't the beneficiary. This call is online for anyone who's interested. I think East Idaho News has it. She explains that people get life insurance going through an agent or applying online. The person who owns the policy has the full control over that policy. The insured person can't change the beneficiary. The policy documents determine who will be paid. Any changes to a policy over $500,000 must be notarized. Calls are recorded for changing beneficiary information. Charles requested change in February 2019. It was emailed to him, and it was returned notarized. He'd made the beneficiary Kay Woodcock. The witness is given the documents in a CD of her call with Lori Vallow. So that's probably the call that we've all heard, I assume, because we don't get to hear it in court yet, at least. The witness listens and verifies it, no objection, and they call the break. But there was an issue at the sidebar earlier with the previous witness, and the court recorder couldn't hear it. Basically, the headsets didn't work, so they had to go up and actually talk about it. So, for the record, we get to know what the 3 jury questions were. One of them wasn't asked. 1. Were payments to Lori Vallow stopped after your investigation? It was asked, and there were no objections. Number 2, if an applicant lied on an application, would the applicant have to pay the money back? Both objected, and it wasn't asked. 3, did Lori notify of her new marriage? Lori objected due to relevance. The state did not. State said it was for motive, and this question was asked as we heard. Now, it sounds like, and I'm recording this on the break, it sounds like they're going to come back from the break and cover those motions next, and then we'll get to more witnesses. But this is part 1. We've already got talk of Bamboo. Bamboo is her crutch now. I mean, she's looking so bad. Like, it's very obvious. Like, it feels like she was personally attacked. It sounds like she feels personally attacked that they went into the fact that the money she received was to go to JJ. That the money she received for Charles's death was to go to JJ. She worked so hard against that idea that someone else must have screwed up, and that gave her the right to blow the money. That's all I can feel from this, is that seemed to be a huge worry for her. I do expect we're going to find out about some spending she did with that money later. Or at the very least, she does. Just very, very weird focuses for her. And she's trying so hard to deny things when there's a computer system that would have saved it. But now you get to see the next part. It should be unsurprising to everyone that there are more juror issues in this next segment of the trial. We'll get there, but first we're back with motions. The state plans to call 2 more witnesses today, and the state expects for their case to be done this Thursday. There was a motion in limine about questioning police. Lori read it, but didn't get to discuss it with her team, and the state says this could be an issue today due to possible cross-examination. The judge says he doesn't know to what extent Lori wants to cross police about why she wasn't arrested that day, why Alex wasn't arrested, or why it took so long for the charges to be submitted. And the judge asks, is that what Lori wants to ask? And Lori says, not in those terms. They aren't on her list, but it will become evident they weren't arrested that day. The judge says timing of the investigation, who was charged, who wasn't charged, would not be relevant. One of the first witnesses there was a question why her and her brother weren't arrested that day. The judge says if she goes down that path, you could open a door. And then he kind of trails off and said it could be reasons it took a while. The jury doesn't need to know about that. Basically saying if you open the door for why they reinvestigated this, you're opening the door to you murdering your kids. Like, that's what he means, right? Like, why did it take so long? Why did the investigation pick up? Well, everything really went rolling when the kids disappeared, right? That door is just always being knocked on. The judge said he doesn't think it's relevant, but if she does want to ask about it on cross, ask to take a break and they'll discuss it then. Lori subpoenaed Robert Bobby Vallow for a date that already passed. Lori says it was a clerical error with an exhibit and it shouldn't have been a subpoena, but she gets interrupted every 20 minutes when calling from jail. State asked to seal everything with Bobby's information. The Boudreaux subpoena is quashed and also filed under seal. Lori hasn't discussed the video motion that's supposed to be happening, so that's kind of delayed. Same witness is coming back in. The primary beneficiary is Kay Woodcock. If Kay Woodcock died, the money would have gone to Nicholas and Zach Vallow. So yes, Charles put protections in place in case Lori decided to kill Kay Woodcock. That's my understanding of that. Lori wasn't even number 2 down the list. His wife wasn't number 2. The life insurance company doesn't tell a beneficiary if they're removed. Banner Life recorded Lori Vallow's call and they play it for the jury. As I said in the last segment, it's online if you want to hear it. Lori gives Charles his name, says Charles is her husband. They ask Lori a few questions. Some of this was covered. Charles died July 11th. Charles was shot. Lori is asked if it was a homicide. She says it was an accident. Lori says she's the primary beneficiary. They tell Lori they will do a review to send to the main beneficiary. Lori is asked how she would like to receive information, and she says email would be great. Witness says Lori said she was the primary beneficiary. Lori says Charles was shot, and Lori said it was an accident. Lori wanted contact by email. I know I'm repeating it, but these were all verified after the fact. Name beneficiary with notice by email. It is standard to wait and look up things after a death claim. They review all changes over the life of the policy to make sure the appropriate party gets the information. Witness didn't know during the call Lori wasn't the beneficiary, but looked it up after. They review policy and claim requirements. They need claim forms and death certificates with the manner of death. Banner Life determined Lori was not the primary beneficiary. Lori was told by email. The email wouldn't say who was the beneficiary or when it was changed. Banner Life would never tell who the new beneficiary is. That's personal private information. Lori called after getting the email. There was some phone tag until she got to talk with the voicemails. Witness listens to the new call they have and confirms it, and now it plays. Lori says she was the beneficiary, and then the last update she has is she's 80%, and then 2 employees were 10% each. The witness said they don't see Lori at 80% at any time. The beneficiary was changed March of this year. I'm trying to figure out, it's March of this year as of the time of the call. Lori says, I'm trying to figure out what he was doing. We have 5 kids. We've been married for 15 years. I know he owes a lot of money to people, and I was afraid they would come after me for money. Now I'm left with none. Did he change it to one person or several people? So, she doesn't have 5 kids again. We've gone through this. She has the 2 kids that were living with her at the time that were murdered. We deal with the business all the time, so I kind of know how it works, but I'm completely surprised. We have a 7-year-old with autism that we adopted together, so I'm surprised that he would do that without telling me. There is nothing Lori can do because it's Charles who owned the policy. Lori asked about her own $2 million policy and if he could change it by forging her signature. So Lori was trying to put on that at one point that maybe Charles was going after her for her policy, but Lori's policy was in Lori's own name, so she had full control over it. But Lori didn't have the policy in her bannered life. Lori would have to call them to ask. The witness doesn't feel Lori understood what was actually happening and like with the insurance policy process, and that Lori did not have a policy with them. There was nothing she could do for Lori. Kay Woodcock got the money after they verified she had nothing to do with the murder of Charles Vallow. Lori has no questions. Which fair, because like, what is Lori going to say here to make herself look better? Nothing. There's nothing she could do. I thought she might, but she didn't. Especially since it was a woman, but she didn't. Next witness is Jeff Moberg, a forensic scientist in the firearms and tool unit. He goes through his training and explains how semi-automatic guns work. Cartridges are ejected as you fire. There are marks on the cartridges left by the gun. You can have marks on bullets too. Can tell a bullet from a casing or a casing came from a certain gun. There's a very basic low-level explanation for the jury that doesn't know anything about guns whatsoever. I'm going to skip most of it because I'm assuming most of you understand the very basics, especially since this is a true crime video. You've heard of like matching a bullet to a gun. The witness was given Alex's gun and casings. The gun was tested, fired into a water tank. He used ammo as close as what was used in the killings, but it wasn't the exact type. 3 shots were fired without issue. Explains you don't reload after each pull of the gun with this type of gun. He was able to determine the bullet was fired by Alex Cox's gun, the one at the scene. The whole process is photo documented, and Lori is up for cross. I cut so much out there, but honestly, most of it is for the jury's benefit. It's not part of the case. It's basic explanations. This is where it gets really interesting. This witness received the request to test the firearm March 2025. He was told on Wednesday and did all the work on Monday. He wasn't sure of the exact date. He checks his notes, report March 4th, 2025. Evidence was actually received February 26, 2025. He received it February 26, 2025. Returned to the evidence room the 4th of March. He was requested to do this by a detective who reached out to him by email asking if he could assist in a rush. He contacted the detective and had the evidence submitted. Detective Duncan asked. So Detective Duncan's the one that asked him. Once he finishes his report, it's reviewed by an examiner, then an admin, then released to Detective Duncan. The photos were attached to all of his case notes, about 13 or 14 pages total. Witness fired the firearm 3 times in testing, and the testing fire was done into a water tank with a tube, with a rest so it fires the same every time. About a foot away from the water. Lori asked if the casings went to the same locations. He said they have a net that catches them. Lori asked if he fired the gun and then moved 45 degrees, the casings would land in the same location. Objection, judge lets him answer. Witness tries to clarify what she means. He said he expects slightly different, but not much. Depends on if it hits or bounces off of something. If fired from the same location, it depends on what is around it, because if you move at all, it is changing the angle, and that might change how it bounces and rolls. Lori asked about the wall, and witness says without knowing the scene, he couldn't say. Lori doesn't want to simplify, but says these things came from this gun. He says correct, he would say that. The testing was done on March 4th, and he says no, the final report was on the 4th, but the testing and the analysis were on the 3rd. Redirect. The casings ejected to the right and up. Casings don't land the same spot if you purposefully don't move. They tumble around the air and bounce. Even trying your hardest to keep as still as possible does not mean casings will land next to each other. All surfaces bounce differently. If firing many rounds, it will land in a general area, a pool. Not small. Turning a gun changes the location of the casing goes. You cannot tell from the casing what is shot 1 and shot 2. There's a jury question. Where would the casings go if it was fired sideways? He shows up or down depending on the way it bounces off of. Basically, you fire it one way, it goes up, the other way, it goes down. The next witness is up, and this is, I'm going to butcher this name, Cassandra Euclid with Chandler Police Department. She works in robbery and homicide. She shares her work history. She was going to a community event and was asked to respond to Lori's home. She did not have a body camera. Fire, she believes, was still there, but they had their own fire responding for her unit. She saw Alex Cox sitting on the curb. He looked normal, with something in his hand. It touched the back of his head. She had no contact with him. She explains people's roles at the scene. She saw another officer interact with Lori and Tylee at the scene, but she didn't know who they were at the time. She identifies Lori Vallow. Lori was standing, not real animated or emotional, talking to the officer. Police cars and crime scene tape are up at the time. Again, they're painting the picture. Lori is bored, basically, waiting to get this over with after knowing her husband was murdered. But this witness at the time doesn't know, on the scene when she saw Lori, that Lori knew. She learned who Alex Cox was, later learned who Charles Vallow was, and later learned who Lori was, and their relations. The witness didn't know Lori knew her husband was dead. She knew Lori wasn't present before she arrived, so she assumed Lori didn't know. She decided with other people that the right thing to do was to tell Lori her husband was dead, a death notification. Tylee and Lori were moved to a van, and they tried to get Lori to leave the van without Tylee to have the conversation. Lori was very calm, not emotional, didn't seem very affected, nonchalant. When they told Lori to get out, she said she already knew that Charles was dead. She was there. Now they're witnesses, and they need to be interviewed. Witness was surprised she didn't have to tell her she was dead, and the demeanor of Lori didn't change after talking about him dying. The witness took Lori and Tylee to the police station. They were taken to the Family Advocacy Center, it's designed for victims of crimes. Very calmer, plain clothes, stuff like that. She had no idea about Lori's involvement or if she knew. Lori talked about Tylee's schooling on the drive there. Lori didn't seem emotional. Lori asked no questions about Alex or Charles. The interview was video recorded. You would think at least you'd ask about Charles, right? Because Charles, in her made-up scenario, Alex, and in her made-up scenario, Alex is being attacked and hit and injured, and she doesn't care about his condition. Lori had a phone on her and told the interviewer her phone number. The interviewer never asked to look at the phone and was never offered to show her phone. The witness wasn't in the house before the interview. Witness didn't know Lori had Charles Vallow's phone with her. Witness expected it to be at the scene. They play a very short part of the interview. Very short. Lori gives one phone number, and the witness learned later that Lori had more than one cell phone. Lori was there consensually as what's believed to be a witness, so there wasn't a Miranda. Another segment of the interview, and I put a note here. If you haven't seen this, I believe I watched the full thing on my videos covering the case in order. Of course, other channels also have the full interview. Lori, on the video, talks about how Charles is all about JJ, never Tylee, and they got Lori a house. Charles is sending threats to her on her phone. He doesn't want a divorce, but she doesn't like him. JJ's adoption and disabilities are discussed. Lori never showed the claim threats, never explained what she meant, and in later days, they learned that the number that Lori Vallow gave them is not the number she normally talked to Charles on. She used another cell phone. Lori says Charles didn't want a divorce, and Lori didn't want to deal with him. Lori says that Charles filed she was crazy and wanted to limit her visitations with JJ, so she abandoned JJ for 30 days in retaliation and didn't talk to Charles. We find out, and it was Kay, it was actually 58 days, and then she showed back up yelling at Charles. Another interview portion is being admitted. Lori objects. The whole interview should be played, and it just gets admitted anyway. Lori talked about abandoning JJ for 30 days and not talking to him after Charles filed she was crazy. Now for the break, but there's a part that wasn't live streamed due to it involving a juror. Yes, juror problems. My biggest fear in this case. A juror said he had an issue with the Social Security after it was brought up with a witness, and he talked to another juror. Juror says he can put his feelings aside and not have it affect the case. Another juror is brought in, number 16. That sounded familiar. So I went back. Number 16 is also the one that saw some of the body cam footage previously. I thought that might get them excluded. But remember, we're already down 2 jurors and we have 2 left for alternates right now. So the same juror is causing a problem. The juror talked to another juror about Social Security and said that Lori was getting was too high. The judge says they can't talk to other jurors, and this juror can stay a juror. So this is a problem. Like, I've seen people like think I'm overreacting a little bit with like the juror issues, but this is a big deal. Like, imagine if these 2 jurors got kicked out. Okay? If these 2 jurors got kicked out, which one of them already was involved in an issue previously, if these 2 jurors got kicked out, there are no alternates. If the one that was late this morning didn't show up or did something and get kicked out, it's a mistrial. We're that close, people. I just want to really put that in. This could end in a mistrial because of the jury. And people were commenting how quickly the jury was picked. Maybe it was too quick. Maybe it was too quick. This is worrying to me because, hey, if she gets a mistrial and this has to all restart, that's more content, right? But it's terrible for the family. It's terrible for a whole new set of jury that has to see all this. Today, they saw Charles Vallow cut open on a table. And if something happens with this jury, you are condemning another group of people to have to see that. I have real worries about it. I'm worried. Because we are at day 1 of week 2. And we are not in a good place. We are back, and the witness didn't know about Charles filing about Lori being crazy. She knew Charles was coming to visit JJ. Lori knew it. Lori knew about booking a room because she booked it for Charles. Another clip of the interview is brought in about Lori talking about those exact things. Lori objects, wanting all of the interview played, but the clip is played anyway. Lori Vallow said that Charles traveled a lot. Lori said his travel was an excuse to not care for his son. Lori said Charles rented Lori and Tylee a house. Lori says she texted Charles the night before the killing. There was another exhibit, another small segment. Lori knew when to expect Charles the next morning. Charles showed up at the time he said he would. Another segment is played. They knew Lori knew Charles was coming, what day, what time, and to pick up JJ. They talk about how Lori put JJ in the car and then took Charles's cell phone. New segment was put forward. Lori objects, but it's still played. Lori says Charles always leaves things in the house, and Lori claims Charles left the phone on the counter. Lori refused to give it back, saying, "Show me your text." Charles is plotting and talking to her brother. They confirm Lori says she got a hold of Charles' cell phone while inside where he left it, and Charles demanded it back. Lori didn't say she gave the phone back. Lori said she left JJ for 30 days with no contact and is now asking why Charles is there. So Charles had to take care of his son when Lori left and is now visiting his son. Lori asked why Charles is talking to Adam, her brother. Witness doesn't know who Adam was or that Lori had Charles' phone at the time of the recording. There was more talk of Charles wanting his phone back, more submitted video. Lori objects again, and it's admitted anyway. She said Charles was screaming at her and reaching for his phone around the house. So at this point, the jury basically is just hearing how Lori lured Chad to a location in the house where he was eventually killed. Lori said it is just her and Charles at this point. The interviewer didn't ask why didn't she give the phone back so JJ can go to school. Lori claims Adam and Tylee showed up. They were in the house and they're there. Lori claims that Tylee poked Charles with the bat and Tylee fell when Charles took the bat. Lori didn't say why Alex brought a loaded gun to her house, and Lori didn't explain why Charles wasn't there. Why Alex wasn't there when Charles showed up. Because remember, if Lori is so worried about Charles, and that's why Alex is there, why wouldn't he be there when Charles showed up at the door? Lori never said Charles started the argument. Lori started it by refusing to give back the phone. Lori claimed Charles came after her with a bat, and while she couldn't see it, she heard a shot. The witness is given another exhibit from the interview, and again, it's admitted against Lori's objection. Lori did so many objections. Lori shows how she says Charles swung the bat. Lori talks about her husband being a semi-pro baseball player. Again, Lori wouldn't give back the phone. Lori said she only heard the shot. Lori said the shot, as in one shot. The witness hadn't been in the resident yet, so going off Lori's descriptions at this point, Lori says she doesn't remember Charles or Alex saying anything before the shots were fired. Another exhibit. Same objection from Lori, but it was admitted. This one was actually the wrong exhibit. They played the wrong thing, something they planned to play later, but it got admitted anyway. Lori said they left after in Charles' rental car. Alex was standing in front of Charles on the floor. And now is the segment about the shots coming up. Same objection admitted. So basically, it's a little out of order. The jury is seeing how happy Lori is in this clip. It's got to be killing her case. It's got to be hurting her case. Like, she's talking about her husband being shot and she's laughing. She's laughing in these clips, smiling. Lori never says she gave the phone to Charles. When her daughter got involved and Charles was still demanding the phone, Lori didn't return it. He was there to take JJ to school, and Lori's brother comes out and she still wouldn't give Charles the phone. Lori never explained why she didn't just hand the phone over. Another exhibit. This time it's a copy of the full interview, which is admitted. They start to play it, I think, but they get stopped. Lori does the same objection, which is funny because Lori's objection is because it isn't the full interview, but this is literally the full interview. It gets admitted, of course. Lori never called 911. Alex Cox called 911. Lori had multiple cell phones. The witness later learned that Lori had Charles's phone but never called 911. She brought Lori, Tylee, and Alex Cox with another detective back to the station. Brought them back to the scene after this. Lori was unaffected and unemotional, chatting, not upset. It was striking. Lori didn't talk about needing to tell people that Charles died. After dropping them off, the witness went into the house. Witness left to work on another case. Later, detectives asked her to get Lori and Alex to come in to do a walkthrough. They called the number that Lori gave in the interview and didn't get an answer. Witness said Alex, Lori, and Tylee did eventually come back to the scene. Detectives said they couldn't find Charles's phone. The witness knew Lori said she had the phone at some point, so asked if they knew where Charles's phone was. Tylee gave it to the witness, and they both gave the passcode. Lori claimed she found the phone in the car. Lori's demeanor is still the same as before. They found it odd that Lori said she had it in the house and wouldn't give it back, but now she suddenly found it in the car. And they show the witnesses Charles's cell phone, and she confirms it. Lori is up to cross. Female witness! So my first thought was that Lori's going to think she wronged her and we might get some fireworks. And little precursor, we do. We absolutely do. Witness says the case agent was Moffat. It moved to Duncan when Moffat was promoted. Witness got the call 10 to 15 minutes after hearing radio traffic about the incident. She didn't see Lori and Tylee arrive. Lori and Tylee were talking to the officer, but she couldn't hear them. And at this point, I believe at this point, I don't think it's my notes, Lori keeps trying to be like, why didn't you see me? Was there an obstruction? She just didn't notice her. Lori, you're not that important. Like, you were off to the side talking to someone else, not loud. You weren't making a scene. Maybe if you had made a scene, Lori, as would be expected of someone when their husband was murdered and they return home in their house covered in crime scene tape, maybe she would have noticed your exact arrival. Lori says, you talked about my demeanor being ordinary, and the witness says, yeah, ordinary. Lori says nonchalant. The witness says, yes. Lori asks for a definition of nonchalant. Calm, detached, things don't matter. Lori asks if she has a degree in psychology. No. Lori asks if she knows how someone should act. And the witness says there isn't one way to act, but the way Lori was acting was striking behavior. At this point, Lori has a sigh, and the way she's talking seems pretty angry. I think she knows her laughing in the interview is a bad look, and it's really upsetting her. Lori asked if it was mentioned Tylee needed her medications from the house. The witness said the search warrant takes precedent. They couldn't enter until after the search warrant. Nothing was removed at that point. But the witness was aware that Tylee needed her medication for her panic attacks. Objection sustained, but the judge lets it be reworded. The witness was aware Lori asked for medication. For anyone just now tuning in, somehow, you've not watched the case, you've not watched the previous parts of this video, you're just tuning into this part. No, this medication has nothing to do with the case and doesn't help Lori at all. Yes, Lori was convicted in the murder of her daughter. This is Lori using a daughter she used as part of her defense, right, of what happened, using her medication to try to harass a witness, knowing that this witness knows she killed the daughter. Could Lori have been calm due to trying to feel strong for her daughter? Objection sustained. That interview footage without Tylee completely disproves that. Right away, everyone knows that. This is Lori trying to go on a revenge tour. This is revenge tour. The detective was being calm and other detectives were being calm. We've heard all this from Lori before, asking about how murder investigators are calm, so why aren't the witnesses calm? We've heard this. The jury's heard this. Lori asked if it was a calm environment, and the witness would disagree it wasn't calm, but people weren't running around being hysterical. And at this point, I just kind of wanted to jump up. You, Lori, you are the one expected to be hysterical in this scenario. The fact you aren't hysterical is the problem, Lori. You are the problem, as you always are. The witness was briefed in a group setting. Lori keeps messing up names and trying to talk about it, getting an objection for testifying. Tylee and Lori were in the van where they were told about the death. Witness tried to get Lori to get out of the van, and Lori said she was already there when it happened and already knew. Lori says, I already knew what? The witness snaps back. Charles had died. I was trying to tell you, not in front of your daughter. And Lori asked, that would have been nice, but that wasn't the point. Lori asked, how did I know you were coming to give me a death notification? Objection, sustained. Lori asked, did you tell me you were going to give me a death notification in front of my daughter? The witness has to explain it would have been redundant to tell you I wanted to give you a death notification, but not in front of your daughter. The witness literally laughs, scoffs, whatever you want to say at Lori, because Lori is basically like, why didn't you tell me you wanted to tell me my husband died, not in front of my daughter, while I was sitting in front of my daughter? And obviously, Lori was never shocked about the death, so it's not like it came as a shock. Lori knew. Lori's whole I was calm is because she knew, but she's still angry. She's trying to find a reason to. This isn't helping Lori's case. This is to insult this investigator, this detective doing their job, right? Lori says, why would I already know? Objection sustained. Both the witness and another were involved in the death notification. Lori said she was there and already knew, and at that point they asked her to come back to the station. Lori asked if they were asked or told they would do it. The witness said it was a consensual voluntary interview. No body cam saw this because no one was wearing it. They voluntarily went to the station and were separated. Lori asked about the interviewing of Tylee. The witness says it was discussed. Lori asked for protocol for interviewing a minor, and the witness has to explain that changes in circumstances. Her saying protocol, honestly, it felt like the invoking of Sarah Boone. I might use that in my title. That might be overselling what happened today, but it felt like Sarah Boone. Needlessly harping on the word protocol to like personally go after people. It's so Boone-esque. I don't know another way to describe it. I'm sure people that watched feel the same way, that seen both. But yeah, the protocol for interviewing a minor changes on the circumstances. The witness is certified to interview children. Asking parents is also circumstantial. Lori's asked if she was asked if Tylee wanted to be interviewed. No, Lori asked if she asked Tylee if she wanted to be interviewed. So Lori's asking if the witness asked Tylee. Objection, hearsay, overruled, and she did ask Tylee. She doesn't know if they were being Tylee didn't know if they were being videotaped, and neither were told. So Lori and Tylee did not know they were being videotaped. Tylee was left alone during a 35 to 40-minute interview with Lori, and not knowing she was being recorded, without her medication. Of course, Lori has to mention about this medication. Suddenly the medication is so important to the daughter that Lori is convicted in the murder of. Yeah, that's crazy. Lori says she was worried about Tylee. Objection to relevance sustained. The witness wore her gun during the interviews and treated the two as victims. The gun wouldn't be the gun. How did they word this? Basically, Lori is questioning the gun being involved, and would a gun be worn due to the child? Like, would a gun be worn to interview a child? And the witness is basically like, it depends on their age. Lori asks, is that your normal protocol? Objection, asked and answers. Again, protocol. Protocol, I think, is going to be so common in this trial, too. Witness explains that this wasn't a forensic interview of a child, but a witness interview. It was almost a victim status, but it was a witness. The Tylee interview was 30 to 40 minutes. Lori asks if she believes Tylee. Objection sustained. We are knocking on that door again. We are talking about an interview that is 30 to 40 minutes long of Tylee, and I cannot imagine this interview gets put in without the talk. I can't imagine how it gets in at all, but even if it somehow got in, I can't imagine it doesn't get in with talk of her death. Right? We are knocking on that door. Again. Of course. Lori asked if Tylee's demeanor seemed genuine. Objection sustained. Did she have reason to believe Tylee was making something up? Objection sustained. Did you learn during Tylee's interview? Objection, hearsay, sustained. Witness was told during Tylee's interview during Lori's interview that Tylee came in with a bat. Was that confirmed by Tylee? The state at this point just sounds pissed. Objection, pretrial ruling, hearsay. Lori wanted a sidebar, and the judge told her, no. This is hearsay. She does not get her sidebar. At this point, Lori flips some pages, which means she was planning to berate this witness about Tylee even more. But she can't ask them now. Lori asks about her and Tylee being left with a victim's advocate, and that happened. After that, they go back to the house. Lori says, you stated I chatted the whole way back. She sounds very annoyed. She does not like this characteristic that she was chatty. Lori asks if it was Alex and Tylee who were chatting, and the witness says, oh, it was you, mostly. So the witness is just like, no, we're not playing this game. You were the one that couldn't shut up. Lori says, it wasn't just me looking out the window and the others talking. No. Lori is trying so hard. It's kind of Sarah Boone-esque. This is Sarah Boone, right? Think of Sarah Boone. When you think of Sarah Boone, think of the case. They kept changing the story anytime a camera wasn't filming. Sarah was so mad at the parts being filmed. They were being misconstrued. And then any segment that wasn't filmed, she had some excuse or reasons or some story. We're getting the same thing with Lori, where she found a gap. She found a gap. She wasn't on video, and she's gonna try to exploit it. She's gonna try to use it. Lori and Tylee and Alex left in a rental car after they got back. All of their vehicles were part of the crime scene. The rental car was not part of the crime scene. Lori asked if she was instructed to come back after picking up JJ, and the witness said, you could do that. Lori asked if I was told to do that. Objection, sustained, testifying, because Lori is testifying at this point, saying, well, I was told. That's testifying. Witness went to the house after they left, talked to detectives, and then went to work on another case. They talked about what they found during the search warrant. Witness doesn't know when Lori got back. Sometime after, though, Lori did return, and they asked where Charles's phone was. Tylee took it out of the cup holder. Lori says, and that's where it was the rest of the day. Which, remember, it wasn't. We know it wasn't. We know that Lori and Alex went through Charles's phone, and there were photos taken, I think, of the phone. We've already been through this. The jury knows better, but objection, speculation, and testifying, and it got sustained. They gave the code. The witness explains chain of custody of the phone after that. Witness handed the phone over at the station. Lori starts to say, according to grand jury, objection, sustained. Lori's got even more for this witness. Lori wants to keep going in because it's a woman who she thinks personally wronged her, and they're going for a break for the day. And there's more. Don't leave yet. There's more. But I really think Lori is going to go after this woman on a personal level, and she wants to try to make herself some sort of like a doting mother to Tylee, because I think she's banking on the fact the jury is never going to find out during this case what happened to Tylee. And now the judge looks absolutely pissed off, and we're talking about issues that can bleed into the next case, okay? We are already into next case problems because Lori is so late on this case. Let's get into it. The judge has to explain to Lori she can't phrase questions as your understanding and what you remember. That's testifying. Sustained objection about the mention of the grand jury. The judge explains why the clips were allowed instead of the full interview, and that the full interview wasn't applicable. The state can't submit self-serving hearsay, so it had to be cut up. The state did submit the full interview, I believe, so that's questionable. To me, that ruins her arguments because the whole thing's going to be available for the jury. Lori talks of a new extraction from Charles Vallow's phone, but they can't open the files. The judge doesn't know what to do since they can't open it. They have someone testifying from the defense side saying someone else might be able to open it tonight. Their investigator, or their expert, they spent 4 hours and couldn't figure out how to open it. The state explains this is raw gray key data that cannot be parsed. You have to put this into Cellbrite to get the data. Lori says that they have Cellbrite on their side, but it won't open. The defense says the state gave them old Cellbrite, and the state says they gave them a reader, not Cellbrite itself. The state says they don't think that what the defense is saying is correct. State has an issue. They're even talking about it because it's like a precluded expert, while the state is about to end their case in chief. And the judge says technically it could be evolved in the next trial. They don't know if that would be allowed then either, but Lori wants their expert to help, wants the state's expert to help. The judge questions if the problem is with the disclosure or who's opening it. Unlikely to actually be an issue for this trial. Basically, the judge is saying no matter what, you're probably not getting anything in, and we're done for the day. So with the Cellbrite stuff, my understanding from the trial is that the raw data has to be put into Cellbrite itself. Cellbrite can then read it and can convert it into something else that a Cellbrite reader can open. Lori has been arguing she didn't get the full data because they got the reader format. So the state gave her the full data, but you can't view the raw data because they aren't paying for Cellbrite. That's my understanding. So this whole thing is just Lori's side either not understanding, which if they're not understanding, how do they have an expert that doesn't know how this works? Sounds like a problem to me. So with all that being said, That's day one of week 2. We've had juror issues, we have vendettas, we have what sounds like Sarah Boone, we got more bamboo. This is a mess. This is a mess. And I feel like as it goes on, I feel more of that narcissist Sarah Boone energy, right? I feel more of that coming out. I really feel it in this case. This feels so similar. Just the way she words things and says her questions, her tone of voice, her inflections. I wonder if we'll get anything about her mental state. I would love to know if she has any diagnoses like the diagnoses were given with Sarah Boone. It might already be out there, right? It's just so interesting. They sound so similar. They would love to be pen pals. That's all I gotta say. They'd be perfect pen pals until the moment they turned on each other, right? With that being said, I do have everything solved for the week. I got my taxes done, so I don't have to worry about that. There's none of that that's going to delay me. Thursday, no problem. I'm going to ignore the game launch. I'm going to cover this and get it out as soon as possible for you all. Again, this weekend, I'm probably going to get things done to prepare for next week, right? Because next week, the state ends, next week's Lori Vallow's side. I don't know what they're going to do. They might not even have witnesses. It's going to be a mess. So I want to be clear for that. So I got to get everything done this weekend. I do want to ask, just randomly, because I have people here, someone's watching. I've been thinking about doing some extra raised garden beds. I normally have one, but like with pricing, I think with like food pricing, it'd be nice to have some more. I'm debating trying to do it with like cheap kiddie pools. I know it sounds dumb, but they're like a wide area. They're plastic. I could like do maybe a food safe black paint so the sun doesn't degrade them as quickly. I've thought about doing that and growing some vegetables in there on some soil that, how do I want to put this? The soil itself is not good. Like the soil in the yard is bad. And I think it would be easier to do it in that type of container. I just want some thoughts. If people have done that before, how to work out. I already do like a raised bed and a few other beds. I've done like a mushroom bed. Those are really fun. If you've never done a mushroom bed, especially a mushroom bed around like your garden vegetables, it is so fun when it works. Sucks when it doesn't, but when it doesn't, if it doesn't take on, it's just more mulch when everything breaks down. I just thought I'd ask since I have people here. I'm considering it because it's cheaper. But yeah, thank you all. As I said, I feel Sarah Boone energy. We're not even done with this witness. I can't imagine what more Sarah wants to ask, but we're technically not done. I could see the witness not even being called tomorrow. I could see, let's call her Sarah, Lori. I could imagine a scenario tomorrow where Lori just doesn't have any questions because her defense counsel is like, you gotta stop, right? But yeah, I'm really interested in people's thoughts on today's because I thought the revenge tour might have been over because, you know, all the people that she personally knows, but this is a woman and she seems to think this woman has personally slighted her, and we can feel that revenge tour energy. We can feel the anger, juror problems. I just want to get through this trial without a mistrial. That's my biggest worry right now, is a mistrial is coming. I hope I'm wrong. I can just feel it. Something feels wrong. We're getting a lot of issues. It feels like we're getting more issues than other cases I've followed. We're down to the wire. Please hold out.